Hi, sir. Good evening.
How are you, Gaurav?
Good, sir. Good, sir. Thank you. We'll just begin now. We have some participants. We can wait for another 5 minutes, but we can start off right now.
Yes, we can be.
Welcome, everyone, to our webinar today. The topic for today is plea bargaining. We have with us Sri Chandra Jit Singh, who is currently the Secretary for New Delhi District Legal Services Authority and is a judge with the Delhi Judicial Legal Services since 2009. Plea bargaining is essentially derived from the principle which basically means I do not wish to contend. The Apex Court has interpreted this doctrine as an implied confession, a quasi-confession of guilt, a formal declaration that the accused will not contend. Plead guilty or bargain for lesser sentence, I would say this is the basic meaning of this concept. Today we have with us an eminent speaker who would discuss the importance of plea bargaining in India, as well as how has the concept emerged and failed in the Indian legal system. Thank you for joining us, sir, today. You can now begin.
Thank you, Gaurav. Thank you for giving me this opportunity to interact with you all on this very important topic. I believe that this is very important for a number of reasons. One, that we all understand that that whatever practices are there in the West or abroad, so we should learn from them and try to inculcate them. So plea bargaining is one such exercise, one such provision or concept which has been adopted from the West. So this is, as we all know, this is very much prevalent in United States of America. And this was discussed for the first time, when I was doing research for this topic. So I was also a little startled that this discussion on this topic, goes back to 1991 in India. That was the first Law Commission, 142nd, report of the Law Commission, which first talks about the plea bargaining. Although they talk about it in different terms, that what is the concession which can be given to the the under trial prisoners, and how the ever increasing number of the cases in criminal courts they can be they can be tackled with. So this was one thing which was discussed and was recommended, and again taken up, and subsequently it has been taken up in the 154th report of the Law Commission of India. And then the Honorable Justice Malimat's committee report is also there, which recommends that we should, we means in India should incorporate these provisions, and subsequently they were incorporated. So initially, there are two things. One, what is the concept of plea bargaining, and second, that how it is working in India, and what are the provisions therefore. If we have to understand the plea bargaining, as it has been said that the first thing is that accused surrenders his right to contest the allegations against him or her, and they, whenever the allegations are leveled against them, they accept it. There are certain conditions that in which that acceptance is to be recorded, but primarily this is the acceptance of guilt by the accused, if we have to simplify this. The plea bargaining in the conservative sense talks about two things. It is the charge plea bargaining and the sentence plea bargaining. There is one more kind of plea bargaining is there, which is fact plea bargaining, but generally these are the two kinds which are more been discussed and are in practice. In United States of America, this plea bargaining happens at the pre-trial stage also, where certain charges are dropped. That is why it is called charge plea bargaining, that a person is bargaining that if he accepts a lower charge, that the prosecution will not press the higher charges. Higher charges means the charges with the higher punishment. So this is charge bargaining. Second is the sentence bargaining, where and primarily in India, when we will be discussing about the provisions, we'll find out that it is the second concept or the second dimension of the plea bargaining which has been adopted. It is the sentence bargaining, which means that once a person has accepted the guilt or has chosen to accept the guilt, then this is there is bargaining is not on the charge but on the sentence. So this is basically a concept. What is the plea bargaining? What is there? And originally it is there for more than a century in the United States of America. And there are certain provisions. It's not like this that before the concept of plea bargaining or provisions of plea bargaining being incorporated in our criminal procedure code, there was no provision where under somebody could accept the guilt. The one chance is when a charge is framed and a person is asked his plea. So at that time also the person is having an option whether he wants to accept the guilt or he does not want to accept the guilt. And the trial will begin only when the person says that he refuses the charges or contests the charge and he does not accept them. So this is one stage. Another is the section 206 in criminal procedure code and section 208 in motor vehicles act. These two provisions are also there, which provide that a person can accept their guilt, and so much so they can accept that guilt in certain cases through means of telecommunication or by telegraph also, along with the sending of the fines. This is specifically applicable in the Motor Vehicles Act. So Section 208 specifically provides the entire procedure that how this can be done. The summons will be sent along with the option to the person to accept the guilt and deposit the fine. So that provision is there in section in the Motor Vehicles Act in terms of Section 208 of that act. So this is there that how this plea bargaining concept is at work. How before incorporation of these specific provisions we had what provision did we have. Now when we talk about any such concept which is there and we have to evaluate it, so we evaluate in terms of its success, quantitative of course, but then we have to see that what is our socio-economic milieu in which we have to adopt this or any concept for that matter. This concept, it is not like this that this is all acceptable in the United States of America also. There are also there people who say that who are there in favor of it, and then there are people who are not in favor of it, and they say that they are in favor of it because of that it will bring up the law and order situation when somebody has a chance that they can get away with a lesser sentence. And another opposition is that it calls for the system to go soft on the persons those who have violated the norms of the society. So again there is a mixed response. The response, it is not that it is only social. It was challenged before their Supreme Court also, Supreme Court of United States of America, and it has been evaluated a number of times. And then the conclusion, if we have to summarize it, it is said that this concept is majorly beneficial, and it is beneficial both for the person who is accepting the guilt and surrendering his right to contest, and it is beneficial for the victim also, the one who has been the victim of crime. And here, a very important aspect of victimology also kicks in. We see that the entire process of criminal trial, the victims comes into picture when there is a conviction. If there is an acquittal, until recently, until when the Section 356A was not incorporated, and subsequent to that, the states have not formulated the victim compensation scheme. The victim could get compensated only in terms when the person is convicted, be it in the terms of Probation of Offenders Act, Section 5 and 4 of the Probation of Offenders Act, or Section 357, because it is only out of the fine which is imposed upon the convict or the compensation imposed upon the convict, the victim can be compensated. So this is another aspect of plea bargaining which we should look into also, that the victim is also made a stakeholder in real time and in real terms, that he has a say in terms in adjudication of the entire process. No doubt the victim cannot decide upon the sentence and everything, But then once victim is there, certainly victim can make submissions about this, and especially when the mutual disposition is to be recorded. So then the opinion of victim becomes very important, whatever be the offenses. So this is the general introduction to the entire concept, that where its genesis are, and even where its genesis are, and it is an application for around 100 years, how it is being perceived there also, how people understand it, how the legal fraternity and legal system of that particular country is also is implementing it, and what are their views on it. So we, as I've just discussed, that it has come to India for decision for the first time in 1991 in 142nd report of the Law Commission of India. But it was not accepted then, and subsequently in the another report, 154th report of Law Commission of India, it finds again a mention and a recommendation. And the reasons are also very interesting, and the reason which the Law Commission has given has also been made the part of the statement of reason and object, which we all know that it is there when any provision is added by amendment, or any laws is incorporated. So the reason which the Law Commission and the legislation has given is that the arrears of criminal cases awaiting trial are assuming menacing proportions. So convincing have been vented in public that disposal of criminal trial in courts takes considerable time, and that in many cases trial do not commence very soon. So the person has to remain in judicial custody, and large number of persons remain. So if we uh, the report is also very interesting, because it has evaluated the concept from the point of view that people have to remain in custody. Although when we see the application of this law, there is no such distinction that only the people who are in custody, they can apply for it. It has been made applicable to the all, but the discussion and evaluation has started from such cases where the under trial prisoners has to continue in custody, as they are not able to secure bail for one reason or the other. So this is the reason that the balancing proportions of the pending cases, pending trials, and also that the time which is being taken, considerable time. So the purpose is to save time, save cost, save anxiety of the person who is facing the trial. So this is the reason which the Law Commission and as well as the legislation has given when they included these provisions in the Code of Criminal Procedure. So if we have to see, what I understood from this for this inclusion of these provisions, though this is not there in statement of reason or the commission's report, is that this is applicable to the first time offenders. If somebody is a convict of the same offense, so he or she cannot apply for the seeking any kind of relief under the plea bargaining. Why I'm saying relief? Because there is a reduced punishment, so they cannot apply for plea bargaining. uh, so why I say that this is a sentencing policy. This can be part of the sentencing policy, because we, especially in the cases which are not of the grave nature, the focus should be that the person who is a first time offender, he be given a chance to reform himself, so that he or she can be part of the mainstream, and they can restart their life afresh, and they can constructively contribute towards the society, to the building of the society, and are able to subsequent help to building up of a nation. So that is basically the parameter of the reformative policy or sentencing policy. No doubt we need to have a balancing act, that the deterrence and the reformation. But this reformation is generally preferred, especially in the cases which are there with the lesser gravity. Uh, and 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 understanding this only, it is also one of the reasons that that section 360 CRPC and the Probation of Offenders Act, they have to be put in practice and that is why specifically a provision has also been incorporated in the specific chapter that they will be resorted to. First, it will be checked whether the and provisions of Probation of Offenders Act are applicable to the case or not, and if they are not, only then the punishment is granted. Otherwise, if it is covered in clause A or B, then we have to take recourse to that. So that is the mandate of the law as per the chapter which has been included in it. And it is so because it was so understood while recommending by the Law Commission. So now this is the brief introduction that how the concept has come into being, how it is applicable, and now we'll briefly touch upon that what are the provisions which are there and what are the cases on which this will be applicable. Because once it is there, only then once we understand that what are the cases on which it will be applicable, we are able to evaluate it better and more accurately. So the cases, we all know that in all the cases where the punishment is less than 7 years, it is the application seeking plea bargaining can be made. The application can be made both in the cases where a private complaint has been made, or where the case has been registered by the police and a charge sheet has been filed by the police. The term used in the statute is the report in terms of 100 section 73, but in general parlance we use the term charge sheet. So I'm using the term only. So in both the cases this can be filed. However, besides this, condition that the punishment has to be less than 7 years, there are 2-3 more conditions in which the application for plea bargaining cannot be filed. One, that it cannot be filed in all the cases which involve socio-economic offences. A list of it has also been, issued by the central government, which we generally find in all the barracks. It is given next to the provision. So all the cases of socio-economic offences, this cannot be the application for plea bargaining cannot be filed or entertained, even if the punishment is less than 7 years. Secondly, if there is any offence against a female, even then the application seeking plea bargaining cannot be entertained, even if the punishment is less than 7 years. Let's say, for example, the cases of outraging the modesty of a woman. In that case also, the punishment is less than 7 years, but still the application seeking plea bargaining cannot be entertained for the reason that the offence is against the women, and the statute bars this. Similarly, if there is an offence against a child, then again this the application seeking plea bargaining is not filed. So in effect, there are 4 conditions which should exist, only then the application can be filed. So now we know the cases where this can be filed. Now we need to understand the mechanism also. And the first and foremost condition is the voluntariness of the accused or the applicant who wants to surrender his right. This is very important, or rather one of the most important aspects of the plea bargaining, because when we are asking anybody to undergo conviction or to surrender right to contest the accusations against him or her, so we have to make sure that the that the acceptance is voluntary. So the process has been made that first an affidavit shall be filed by the along with the application. Application will be prepared giving the brief of the case, and also that the accused wants to make the make a plea of guilt, and along with that affidavit of accused will be filed. In that affidavit, the accused will make 2 declarations. One, that he is making or he's moving the application voluntarily, and second, that he understands the nature and consequences, and additionally he will also say that he is not a previous convict of the same crime. That also we need to understand that the word used is of the same crime. So there may be a contention that although it applies to the first offenders, so is there is a subcategory that it has to be a first time offender of the same category. That is slightly contentious, but the term used and the literal when the words are clear, we have to give them the literal construction. The term used is that the applicant should not be previously convicted of the same offense. So same offense. So if there is a different offense, then for every offense the accused is given a separate chance. So that is the literal construction of this. So these three things he will have to make an affidavit. First, that he is not previously convicted of the same offense. Second, that he is making the applications voluntarily. Third, that he understands the nature and consequences of accepting the guilt. Once this application is there and it is accompanied by the requisite affidavit, the notice will be given to the prosecutor or the complainant, as the case may be. If it is a state case, the prosecutor will be given a notice, and if it is a complaint case, then the notice will be given to the complainant. It is not like this that the IO will not be called, as we are saying. This is the first process where we give the notice after being satisfied with the application. So once that notice has been served and the court is satisfied that the application has been made voluntarily, the accused understands the consequences and the nature of all of the of making the applications. So then, despite his affidavit, what is required is that the presiding officer should once speak to the accused in person, so that the accused he has a personal satisfaction also that that the accused actually understands the nature and the consequences of the plea which he or she is going to make. So that is the first thing. And now the accused has given an affidavit. Now we need to proceed further. So as I was saying here, this is a place where the victim is also given a chance. So we'll resort to the provision which is Section 265B, that once the application is made, the notice has been given, then as per 265C, there are guidelines for mutually satisfactory disposition. So this mutually satisfactory disposition has to come up between the accused, the prosecutor, and the investigating officer of the case. The responsibility of court is that they have to see that it has been done the mutual satisfactory disposition has been done in a fair manner. There is no coercion on anybody's part. There is no nothing undue in the entire mutual satisfactory disposition. It has to be to the satisfaction of all, and it has been fair. That is the responsibility of the presiding officer. As such, they are not required to participate in that, but the only thing is that they need to oversee the entire proceedings. And when it is a case which is otherwise than on police report, means it's a complaint case, then the requirement of IO is not there. But again, the parameters will remain same. That the court will oversee the mutual satisfactory disposition, which is MSD we call it generally. That it has been fair to all. So why as the name also suggests that the mutual satisfactory disposition. So it has to the satisfaction of all. All means prosecutor, the investigating officer, victim, and the accused. So they they talk between themselves that what are the what are the conditions or what are the terms they may lay to this. So this is entirely voluntary, again voluntary not only for the accused but for the rest of the stakeholders also. A victim is not obliged that he has been called to discuss it with the other stakeholders. So it means there is any obligation on the part of the victim that he has to accept it. And another thing is that we need to although it is not it generally doesn't happen, but we need to understand that it is the victim who has to be called. It is not the complainant. Sometimes the complainant and victim are not the same. Since generally they are the same, so we refer to this as the complainant, whereas it is the victim that who has to be called. and let's say if the victim is somebody who is a minor, then he can be represented through his guardian also. If there is an accident between and a child has been injured due to that, the child becomes the victim. Then the child has to come and give the consent. So we all know that in law the child cannot give the consent, or the consent of child has its own consequences. So in this mutual satisfactory disposition, which will be a kind of contract between all the parties, so they will have to the child has to be represented by the legal guardian. So this is there. So once this mutual satisfactory disposition has been worked out, the court will prepare a report, and after the observations of the court, the further proceedings shall be taken up. It is here I was referring to that provision of section 360 and provision of offenders act and the minimum punishment. So the next once the plea has been accepted, a plea of guilt has been given, it means the accused stands convicted. That is the natural consequence. So after that, now we come on to the sentencing, and it is here the provisions will also reflect that the plea bargaining actually begins, because the accused will have something to look up to now. So first thing, this section 265E says that the word user that court shall award compensation to the victim in accordance with the judgment on the punishment, and releasing the accused on probation of good conduct or after admonition 360, or dealing with the accused under the provisions of Probation of Offenders Act. So the word used is shall. So this is first of all, whenever a plea bargaining is happened, so this is 265E clause A has to come into play. If it is not applicable, only then the other provisions shall be applicable. The other provisions are, let's say that it is not applicable and there is a minimum punishment. And in case of minimum punishment, half the punishment is to be awarded. And if there is no minimum punishment, then 1/4 of the punishment is to be awarded. So this provision becomes very important. So if any one of us is representing the accused, so whenever this plea has been has been accepted, or plea has been entered into, and mutual satisfactory disposition has been worked out to the satisfaction of all, and the court is also satisfied that this is fair, then when there is a hearing on this point of sentencing, so one must emphasize on this provision which is there, 265E clause A, that this is the first thing, that it has to be seen, it has to be seen that whether the accused, whether the convict now can be released on on probation or after admonition or as per Provision of Offenders Act. This is the first thing. If that is not applicable and there are other conditions, then the other things has to be resorted to. So once the accused has understood the voluntary nature, the consequences, and and all the entire process has undertaken, the mutual satisfactory disposition is worked out, the sentence has been given, the judgment shall be pronounced. Now there are 2-3 things. Once the judgment has been pronounced, so will the convict now has any chance, if he believes that he did not understand it correctly, or he did not expect a sentence, or if he feels that the sentence is harsh, so can he challenge that, or is there a possibility of any appeal in this? So earlier also that if we for once keep aside the provisions of plea bargaining also, the general provisions of appeal also provide that once a person has accepted the guilt, there cannot be a challenge to that acceptance on merit. However, the legality of sentence can be challenged. This is there in the chapter on appeals. But here in this chapter on plea bargaining, it has been added that there will be no appeal at all in terms of legality of sentence or on the or on the acceptance of guilt, which otherwise also is not there. However, the supervisory rule of Honorable High Court and the Honorable Supreme Court is not ruled out. If somebody feels aggrieved by any decision of the court, and the statute has taken away the right of appeal, still the statute has made an exception that they can approach the Honorable High Court under the writ jurisdiction and the Honorable Supreme Court also under the writ jurisdiction. However, the regular appeal cannot be filed even on the legality of the sentence, which otherwise can be filed if there is a judgment of appeal. Let's say on the charge somebody has accepted the guilt and he has been punished, and in such a case there can be appeal on the point of legality of the sentence, but there cannot be appeal on the merit of the conviction. But here, the merit of conviction and as well as the the legality of sentence, both cannot be challenged. And there's a specific provision has been provided that this provisions of this chapter will have precedence over all the other general general provisions. Then this act does not apply to juvenile or child as defined under the Juvenile Justice Act. Meaning thereby, if there is a child who is facing any trial, children in conflict of law as per the Juvenile Justice Act, we call them. If there is any CCL and he is facing trial of any commission of with the allegation of commission of an offence, that juvenile or child does not have an option to move this application for plea bargaining. It has its own reason, because this entire scheme of Juvenile Justice Act has an entire different basis, which is the best interest of the child. And there also, even if the child is convicted, Section 19 will come into picture, that will not be recorded. So the child is not has not been given an option that he can accept the guilt or or surrender the right to contest the case. This has another reason that child is not able to understand what are the consequences, what will be the gravity, what will be the consequences of accepting the guilt or surrendering the right to contest. The other way, when there are issues of financial benefit or loss, then the an option has been given that the legal guardian can still take a call if it is for the financial gain of the child. But in this case of criminal trial, this has been given a total no-no, that the child, if child is facing any trial, the child cannot avail the option of accepting the guilt and surrendering the right of contesting. He cannot move an application for plea bargaining as far as we are option to move the application for plea bargaining is concerned. So this is basically the provisional structure, the how it has come into being. And now if we have to see that how this has worked out in the courts, so we have to see that there are many stakeholders in this. First, that a first time offender, somebody who is facing the trial, sometimes with the anxiety that they want the proceedings to end soon, and for any number of reasons, when trials take a certain time, and they believe that they are not able to endure it and they want to end it, so they simply move this application. And at times they do not understand the exact nature of the application also. So it becomes very important that as legal professionals, be it on bench or be it in bar, when any such application is moved, we must counsel the person who is facing the trial that no doubt this is an option which is available, but then it should not be availed only for the reason that he is unable to endure coming and attending the proceedings. This should not be the reason, because mostly when I had to deal with such applications, this is the major reason which everybody gives. After that, they certainly say, no, we understand the consequences and everything, we are doing it voluntarily. Then they insist on that also. But but their primary response when we speak to them is this. So this becomes very important, that this provision of all that, any provision is not in subsistence. So it is in subsistence, so that anybody who is at fault, they may be corrected, or they may be brought to justice. But if there is any case when somebody just want to get rid of the case, so this should not be an option. So this is one thing, that when we are moving the application, we all must be careful whether we are entertaining it or you are drafting it. We all have to be equally careful. This is one thing. Second thing is, then sometimes accused understands that there will be no sentence, or there will be a very soft sentence, or something like something of the similar nature when they are moving the application. So I think the biggest parameter of voluntariness is to ensure that the accused applicant understand that what he might face, besides facing the sentence, or the term in jail, probable term in jail. The accused applicant must also be informed that there are other consequences of the conviction also. For example, I remember a case where a young person has moved an application seeking plea bargaining, and the first question when I asked him about his voluntariness is that does he understand the consequences of of accepting the guilt. He said that he does, and he might go to jail also. He understands this, but I told him that there are other consequences of accepting the guilt also. It will be recorded in records, and there are certain kind of jobs, especially the government job, where they seek declaration regarding your conviction, and then there are other attending consequences of similar nature to this. So then he said no. This was a case of rash driving. He said no. He wants to contest it, because he is trying for the government services, and if he accepts the guilt, then he will surrendering his all the rights. So this is also very important that we inform them, so that they are able to take the informed decision. Sometimes the applicants just press that this application be disposed of, or they be heard, they understand everything. Still, they should be given a chance to think over it. What practice I generally have is that even if once I have asked a person about the voluntariness, we still give them one more chance to go back home and think about it, so that we are sure that person is making an informed decision. So the biggest challenge before the before us is that we must make sure that the person is making the application voluntarily. He understands the nature and consequences of making the plea, entering the plea, and also that he makes an informed decision. So all kinds of aspect should be covered, and then no doubt whenever we are trying to implement anything, and especially something which is new, now this is relatively there in our system for around a decade. So we know a little more about it, but still we are evolving through it. So we need to understand what are the final nuances, that how we need to convey it, what are the cases where it cannot apply. This is everything is there. As Gaurav has in starting said, that we need to understand this, whether it failed or not. To my understanding, that there can never be a position where we say that anything has failed entirely, or we say that anything has failed, anything has succeeded completely, because failure and success has different parameters also, and they keep evolving also. So we need, if something is failing or falling short of the expectation, then we need to find out the ways also, that what is it that we are not able to reach what is expected of us. So we need to find out those reasons also. So one reason which I could find or understand is that there is sometimes absence of informed decisions. And so whenever the accused applicant is asked about by this, so and when they understand about it, so then they try to they want to put point fingers on somebody that I was not properly informed of this. So if you really want that the system should work and achieve its purpose, and that we are able to make our little contribution wherever possible, so the informed helping an applicant to make an informed decision is the foremost thing. And also to informed decision will ensure the voluntariness, so they go hand in hand, that that we are able to we are able to make our make our effort towards working of these provisions and the system as a whole. So with this, I rest my words. I thank you all for patiently listening me, and I once again thank you, Gaurav, for giving me this opportunity.
Thank you, sir. Sir, we'll take a few questions. There's some interesting questions. One of them is, does understanding the nature of such an application include the necessity for the victim to know that there can be no appeal after such conviction or at any stage?
Yes. Now, since the victim has also been given a right that that they can directly appeal, even if state does not want to appeal, there are certain cases in that. So in the mutual satisfactory disposition, so it becomes one of the parameters that victim we also appeal, that whatever is the sentence, whatever is happens here will end here. And if they have to challenge it, then they will have to go to the either Honorable High Court or the Honorable Supreme Court. So again, the same thing, that whatever decision is to be taken, it has to be an informed decision. But this is a good point. It's been a learning. So whenever next, whenever is the chance, so if we have to hold this plea bargaining, so we'll certainly inform the victim also that nobody can appeal from it now.
Thank you, sir. So the next question is by Rajat Bansal, which says, if someone has forged the passport and prepared a new one, to whom the court shall summon as a victim, or the court shall not summon anyone?
See, once any document which is a state document, it has been forged. This has been in cases. This is one case where document has been forged. There are other cases which are there under Section 25 of the Arms Act, that who is the victim and who shall be called. In all these cases, that we have to inform the passport authority, and in other cases, if the any permission is required for prosecution, so that that authority is also required to be informed that whether they want to enter into plea bargaining or not. So in such cases, the passport authority should be informed, and whatever call they take, then it is up to them.
Thank you, sir. So the next question is by Raminder Singh. It is, how do we differentiate the voluntary confession and admission of charges, or the guilt under plea bargaining?
See, all these things are the same. The only thing is that there is no bar in acceptance of charges or voluntary confession of the guilt. Why I say there is no bar means that the first time offender also, the second time, third time, they can accept the guilt as many times as they want. But as far as plea bargaining is concerned, it can only be moved by a first-time offender if there is a person who has been convicted. I am saying that if there is somebody who has been convicted, then that person cannot move the application of a plea bargaining. But the same person can accept the charges whenever they are read over to him, so he can accept them. So there is distinction to the extent that who can apply and who cannot apply.
Thank you, sir. So the next question is by Malika Sharma. She asks, can one plead guilty after the charges have been framed?
See, there is a recent judgment of Honorable High Court of Delhi where they say that there is no stage where one can just plead guilty after framing of the charges. But to move the application for plea bargaining, there is no such bar. And if all other conditions are complied with, then the application for plea bargaining can be moved. But as far as accepting the plea is concerned, will be guided by the latest judgment of the Honorable High Court.
So the next question is, so if once the application of pleading guilty has been rejected by court, then would it be hardship for the accused to prove innocence for himself before the same court?
Thank you for this question. This is the one point which I left out. Once it is there, there is one answer in theory, and there is one answer which is there on the which has a practical dimension. So the confidentiality of the proceeding is one of the feature which is there of the plea bargaining. So whatever, that is why in Delhi we have a practice that in the court where the trial is pending, they do not deal with the application of plea bargaining. If any application has been moved by the accused for plea bargaining, that application shall be marked either to another court through CMM Sahab, or directly to the link, as whatever is the arrangement in any district. So the application is dealt by the another presiding officer, another judge. This is there to avoid any kind of prejudice in the mind of the trial judge. But all said and done, one can always be suspicious that once an application has been moved, so what will be its impact? So whatever somebody may think of this application, but this application or the proceeding of this application as per law cannot be used against the accused. They can only be used in the proceedings for plea bargaining, and once the plea bargaining proceedings are complete, whether they are they are successful or they are not successful, they will not go back to the trial court. They will be sent to the record rooms from there, and the only one line order sheet or a very brief order sheet will go to the court concerned that the plea bargaining proceeding could not succeed, and the reason of success of not succeeding also will not be shared. Only the result will be shared. This is to avoid any kind of premature opinion upon the trial judge. And in theory also, the proceedings cannot be used at all at any place except in the proceedings for plea bargaining.
So the next question is by Anisha Agarwal. She says that does the I'm sorry, so the question is done. The next question is, so this question is being repeated. I suppose you need to clarify this again. Can this application be moved at any stage of the case, even before pronouncement of judgment? A lot of people say that it's not clear in the CRPC at what stage can this application be moved. If you could explain further.
See, once it says that it can be moved, it cannot be moved at one particular stage. So it means that the application can be moved before the pronouncement of the judgment, even if the statement has been recorded, and after that a person that he wants to accept the guilt, if still they can application. But once the judgment has been pronounced, then I have my reservations that the application cannot be moved after that, because the finding has already come on the record, and a person cannot take advantage of the provision just to have a lesser sentence, try to have a lesser sentence.
Thank you, sir. So the next question is by Anisha Agarwal again. It says, can we say that the compounding of offenses and plea bargaining are basically of similar nature? And what are the reasons for the same if they are of similar nature? Like, do you think they are of similar nature? If yes or no, just any reasons for that?
They are not at all, of similar nature. Compounding means that the victim and the offender, they came together, and there is a category of offenses wherein the compounding can be done, and they both have reached a situation where victim says that I forgive the offender, and this technically we call compounding. This can be with compensation, without compensation, and the only stakeholder in the process of compounding are the victim and the offender. Nobody else is required in that. IO and prosecutor are not required in that. And the another major difference, or rather the biggest difference, is that compounding of offenses results in the acquittal of the accused. That is a necessary consequence, that once an offense has been compounded as per law, it will result in the acquittal of the accused. But in plea bargaining, the person is accepting the guilt, and there will be conviction of the accused, and whatever the sentence or provision of is to be given, that's a subsequent thing. But In compounding there will be acquittal, and in plea bargaining there will be conviction. So they are not same.
Thank you, sir. So the next question is, if the accused has been convicted by the court under section 325 IPC in plea bargaining, but later on the victim dies because of the consequences, can the trial be started again?
See, the principle of section 300 will kick in, that and subsequently the person has died. What are the reasons for that? If the conviction plea bargaining has been done, so there are a lot of things. This is quite a hypothetical question, that what are the reasons that person has died, what is there. So section 300 will be applicable if all the charges which were possible at the time that once the trial has begun, that has been put in, then it will not be there. But if it's a subsequent circumstance, it's a subsequent development, and even if the case has been decided, this section 300 will not be applicable, and there can be a retrial.
Thank you, sir. So the next question is the Shivam Sharma. It actually has 4 parts. The first is, can you highlight the circumstances in one, if accused does not agree for plea bargaining after knowing that the court is going to sentence him to higher punishment than he thought initially? What do we do in that scenario?
Once accused say that he does not want to enter into plea of guilt, then nobody can force him. It is his choice. It is as simple as that. Whatever is the reason, even if this is one reason that he is apprehending a higher sentence, if he says that I have a change of heart, I don't want to accept my plea, I am innocent, so nobody can say anything to him. So it has to be voluntary at all the times, from the beginning till the end. Chooses that he does not want to enter the plea of guilt, then it is his choice. So the application will be disposed of accordingly, and his plea will not be recorded.
Thank you, sir. So the next part of the same question is the role of victim while disposing of a plea bargaining application, and can the victim appeal against it?
See, as far as appeal is concerned, we have already discussed, and the role of victim is concerned. The victim has an equally important role, that because unless mutually satisfactory disposition is not reached at between all the stakeholders, the further proceedings will not take place in the plea bargaining application. So if the victim does not feel that he is satisfied what is being offered, or what are the terms of the mutual satisfactory disposition, so he has all the right to say no to this, or he simply say that he wants to continue with the trial of the person, and he does not want to enter into any kind of compromise with the person. So the victim has equal important choice, and he has the equal role in the entire proceedings. The only thing is that he cannot initiate the proceeding. If the proceeding of plea bargaining are to be initiated, they can only be initiated by the accused. But once they are initiated, then victim and accused have the equal important role.
Thank you, sir. So the third part of the same question is, this is just the second last question we have. It is, can a second application be filed for plea bargaining if the first one has been rejected?
The second plea bargaining, there is no bar that the second plea bargaining application cannot be filed, but then we have to see that what was the reason for rejection of the first one. No doubt we are not able to, as a trial court does not know what are the reason of the rejection of the first one. The only thing, as a trial court, one must be at guard, or while drafting anything, one must be at guard, is that the first one was not rejected because of the reason of previous conviction. Because if it is a reason of previous conviction, then it is there will be filing a wrong affidavit, which can have its own consequences. So, but besides that, the second application for plea bargaining can be filed, because victim in first place might not agree, and subsequently they can be change in circumstances and they agree to it. So if the application, but the only thing we all must at the guard is that the application should not have been rejected for the reason of existence of previous conviction for the same offense.
Thank you, sir. And so the last part by Shivam is, is there any effect or what are the consequences or options of the accused if the victim is not appearing in court even after he's been served in the case of a plea bargaining application?
It's a gray area. It's a gray area. Technically, we cannot proceed with the application once a victim is not appearing. But then we have to see the reasons also that why victim is not appearing. Uh, if it is the reason is that I'm just taking a situation because not directly related to the question. Let's say that victim is not appearing with the report that victim has expired. Then the LR of the victims can be summoned. This could be one situation. But besides that, if victim is not appearing despite service or he's court is unable to serve on the victim, so technically the proceedings cannot go further. They should be sent back. The application will be reported back that it was not successful.
Thank you, sir. So we also have with us Mr. Bansal. He would like to ask a question or two, I believe.
Yes, Mr.
Rajat. Good evening, sir.
Good evening. How are you, Rajat?
I'm good, sir. I'm good. How are you doing, sir?
I'm good.
Rather than asking questions, sir, I would like to thank you for this enlightened session. As we all know, if you are a practicing lawyer in Delhi, then you must know each and pro and cons and every element of the plea bargaining, because plea bargaining is very much prevalent in the district courts in Delhi. So this was a really enlightened session, and you have also cleared a number of doubts of mine also, sir. As I am also doing the plea bargaining, but still there are a number of doubts. Those were there in my mind, and those are cleared by you today, sir. And thank you very much. Thanks a lot for this, sir. Over to Gaurav now, sir.
Thank you, Mr.
Gaurav, regarding the question where it was that the person was convicted for the person entered into plea bargaining under 325 and subsequently the victim has expired. So that will be covered by clause 3 of section 300. It says that if somebody has been, convicted or acquitted of any offense and subsequently due to certain circumstances, person could not be charged for an offense, and the circumstances are additional circumstances after that decision. So the trial could take place. The principle of double jeopardy will not apply. So this is there in clause 3 of section 300.
Thank you. So that was Mr. Bansal's question only. He only asked that question from us. And so just 1 and 2 last questions. We still have another 5-10 minutes. So someone on Facebook Live has asked the question: is plea bargaining and non-prosecution agreement, if it exists in India, the same thing?
Plea bargaining and
the non-prosecution agreement, I believe that does not really exist in India, but are they the same thing in concept?
Non-prosecution agreement, they can be overlapping, but they are not the same thing, because prosecution means that victim says that that essentially means that victim is withdrawing from the prosecution, or there is a concept of withdrawal of prosecution by the state, but then it has its own entire procedure. Section 321 is there, so it is the only thing. But for that, the prosecutor has to move the application. Victim does not have an option that they can withdraw from the prosecution. It is for the state who has to take the decision, because it is widely because it is basically the concept of criminal law that any crime is a violation of the norms of the society. So the society as a whole can take the decision, and that in turn has been given to the state. So section 321 is there, which has a no prosecution concept, but then that decision is to be taken by the state. But then they again are different, because in plea bargaining the consequences are of conviction, but there will be different consequences in the in withdrawal of the prosecution.
Yes, sir. So thank you. And so just the last query: why do you think the concept of plea bargaining is not that prevalent in India, and why has it failed as a concept, as a machinery? Plea bargaining is used all over the world so extensively. Why does it fail in India?
when we say it's very strong statement, when we just take to one extreme to the other, that it has completely successful or it has completely no as such quantitative data to support this, that this has failed. And if we can rephrase this, that this is not as popular as one expects it to be, so then there are certain reasons for that. The reasons are multifold. If we can touch upon one or two, is that our socioeconomic milieu, that everybody believes that if they have not done it, they don't want to accept it. This is our first condition. And secondly, I believe that even if somebody who has somebody socio-economic factors choices, if somebody has accepting the guilt, how this will be taken up in society, especially our society, so that is a consequence which weighs heavily on the minds of the other. So that is why it is not popular with all. And there is a concept that people believe that they have been falsely implicated, or there could be there are other reasons also, but these are the two major reasons I believe that the socioeconomic condition which is prevalent, and one reason, if one could say, is the percentage of conviction can also be the reason that somebody may say that why should I accept the guilt. But to my understanding, this is this social factors is one of the biggest factors which plays with the applicants, that they don't want to go for the plea bargaining.
Thank you, sir. Thank you so much for joining us today. Thank you for an enlightening session. I really learned a lot myself. We'll be troubling you again shortly for some other session on all the other aspects of criminal law for sure. Thank you to all the participants for joining us. You can give the feedback directly to Lawyers Club India. You would receive an email about it, or you can just log on to their Facebook page or Twitter and then leave feedback for the sessions. Thank you so much, sir, for joining us. Thank you, Mr. Bansal, also. Have a good evening.
Thank you.